Good afternoon. It's lovely to see you all today. Thank you for joining us for the Harvard Law School Library book talk on comparative and capital punishment. My name is Jocelyn Kennedy. I'm the executive director here at the Harvard Law School Library. We have a copy of the book outside if you want to flip through it, and if you'd like to purchase it, it's available through the Coop. It's also available to be checked out from the library and as part of our online package with Elgar, so you could read it online as well. I want to thank the Dean's Office for their generous support of our book talks and the East Asian Legal Studies program for co-sponsoring today's talk. Today's talk focuses on comparative capital punishment, which offers a set of in-depth, critical, and comparative contributions addressing death practices around the world. The book's contributors address the social, political, economic, and cultural influences on both retention and abolition of the death penalty, and consider the distinctive possibilities and pathways to worldwide abolition. Our speakers today are the book's editors, Harvard Law School professor Carol Steiker and Jordan Steiker from the University of Texas. They are related. Other discussants include Gerald Newman and Bill Alford from the Harvard Law School and Margaret Burnham from Northeastern University School of Law. Carol Steiker is the Henry J. Friendly Professor of Law and faculty co-director of the Criminal Justice Policy Program at Harvard. She specializes in the broad field of criminal justice, where her work ranges from substantive criminal law to criminal procedure to institutional design, with a special focus on issues related to capital punishment. She's also the author of Courting Death, the Supreme Court and Capital Punishment, which she also co-authored with her brother, Jordan Steiker. She's a graduate of the law school, where she was president of Law Review. She clerked for Judge Skelly Wright of the D.C. Circuit Court of Appeals and Justice Thurgood Marshall of the United States Supreme Court, and was a staff attorney for the Public Defender Service for the District of Columbia, where she represented indigent defendants at all stages of the criminal process. Jordan Steiker holds the Judge Robert M. Parker Endowed Chair in Law at the University of Texas at Austin School of Law, where he teaches constitutional law, criminal law, and death penalty law, and is the director of the law school's Capital Punishment Center. He also served as a visiting professor at Harvard Law School many times. Together with his sister, Carol Steiker, he co-authored the report of the ALI prompting the withdrawal of the death penalty provisions in the Model Penal Code. He's a graduate of Harvard Law School and served as a law clerk to Justice Thurgood Marshall. Gerald Newman, so skipping over Bill, sorry, is the J. Sinclair Armstrong Professor of International, Foreign, and Comparative Law and the co-director of the Human Rights Program here at the law school. He teaches human rights, constitutional law, and immigration and nationality law. His current research focuses on international human rights bodies, transnational dimensions of constitutionalism, and rights of foreign nationals. He is the author of Strangers to the Constitution, Immigrants, Borders, and Fundamental Law, and co-author of the casebook Human Rights. He is a graduate of Harvard Law School, MIT, and Harvard College. Bill Alford is the Vice Dean for the Graduate Program in International Legal Studies and serves as the Jerome A. and Joan L. Cohen Professor of Law. He's the founding chair of the Harvard Law School Project on Disability, is the director of the East Asian Legal Studies Program, and is lead director and chair of the Executive Committee of the Board of Directors of Special Olympics International. He is a renowned scholar of Chinese law and legal history. He's a graduate of the law school, Yale University, at the University of Cambridge, and Amherst College. Margaret Burnham serves as the University Distinguished Professor of Law at Northeastern University, where she is also the founder and director of the Civil Rights and Restorative Justice Project, which conducts research and supports policy initiatives on anti-civil rights violence in the United States and other miscarriages of justice between the period 1930 and 1970, including one federal lawsuit in which her legal team accused Franklin County, Mississippi law enforcement officers of assisting Klansmen in the kidnapping, torture, and murder of two 19-year-olds. Professor Burnham's fields of expertise are civil and human rights, comparative constitutional rights, and international criminal law. She began her career at the NAACP Legal Defense and Education Fund. She was the first African-American woman to serve in the Massachusetts judiciary. And in 1993, South African President Nelson Mandela appointed her to serve on an International Human Rights Commission to investigate alleged human rights violations from the African National Congress. She's a graduate of the University of Pennsylvania Law School. Tougaloo, did I pronounce that correctly? Nope. College, and as a former fellow, I want you to correct me, and as a former fellow at the Bunting Institute at Radcliffe College and the W.E.B. Du Bois Institute for Afro-American Studies here at Harvard University. Please join me in welcoming today's guest, which for what I imagine is going to be an amazing conversation. Thank you.
Welcome, and thank you for coming out to this event about our book on comparative capital punishment. Warm thanks to Jocelyn Kennedy and the HLS Library for putting together this event and this great series of events about books, and especially to June Casey for her excellent organizing of this event. Deep thanks to Bill Alford, Jerry Newman, and Margaret Burnham for engaging with our book today. Jordan and I are co-editors of this volume, which follows an earlier co-authored book on the American death penalty entitled Courting Death, the Supreme Court and Capital Punishment, which was published by Harvard University Press in 2016. This comparative book expands the scope of our inquiry from the national to the global and brings in transnational and comparative approaches to try to understand the trajectory of the death penalty around the world. So where does this book fit in to what's already out there? There are a lot of reports and other factual material available online, published by international anti-death penalty advocacy groups like Amnesty International and the International Commission Against the Death Penalty, among others. There are also a wealth of scholarly works about the death penalty around the world, the most comprehensive of which is the terrific book by Roger Hood and Carolyn Hoyle called The Death Penalty, A Worldwide Perspective, published by Oxford University Press, now in its 5th edition. I should note that Carolyn Hoyle is also one of the contributors to our volume. Much of the scholarship in this area tends to be organized geographically because people tend to be experts in particular countries or regions. And a lot of the treatment of the death penalty around the world tends to be more on the factual than the analytical side. So our goal was to produce less of a comprehensive compendium, which has already been done masterfully, but rather to try to pull together a set of in-depth, critical, comparative essays that get more into the why than the what of things, and that project more into the future. Our contributors include both scholars and anti-death penalty lawyers who have engaged in litigation and advocacy in different settings around the world. Jordan and I organized the volume thematically rather than geographically, with separate sections on substantive death penalty law, procedural law, administration, institutions, and a final section on the future of the death penalty. Jordan and I are also contributors to the volume as well as editors of the volume. We wrote the final chapter in the book, which addresses the prospects for global abolition of the death penalty, looking at circumstances that have contributed to the stunning decline in the death penalty in many parts of the world in recent decades, and also at circumstances that present challenges to truly global abolition. Our chapter is what led us to choose the cover art for this book. Whenever a country or an American state abolishes the death penalty, the city of Rome lights up the Colosseum to mark that occasion. Which is just kind of ironic, given that the Colosseum was where the Christians fought the lions as a particularly brutal form of punishment. But they're not doing it ironically. It's like totally in earnest. The cover captures one of those lighting ceremonies, and this cover is of the lighting ceremony that marked the abolition of the death penalty by the state of New Jersey in 2007, and that lighting ceremony included the projection onto the Colosseum, I don't know if you can see it from where you're sitting, of the words, "No justice without life." We really look forward to hearing the thoughts of these very expert commentators. Jordan and I will offer brief responses when they're done and look forward to hearing your own questions and comments. Thanks for being here.
So thank you. We're here to talk about an extraordinary book on a very somber topic. In preparing to talk today, looking at the book, I was thinking, well, what can I add to all that the editors and authors have managed to put in the book? As I read through the chapters, some of the chapters raised questions in my mind, and I thought, here's something I can talk about. And then I kept reading, and I came to another chapter, and there it was discussed. And so I think what I need to do is just offer my own reflections on some points that the book does already make, which I'll offer from the perspective of human rights advocacy and human rights institutions aiming at the global abolition of capital punishment. The book points up several dilemmas in this project, and that's what I'd like to talk about. The first one is that abolition of capital punishment is often an elite project. Well, you could say that about human rights frequently, but it's also true here, that it's often an elite project. It's often trying to achieve something that is not popular with the population of citizens where the abolition is going to take place, or something which is strongly opposed by segments among the citizens. And this normal feature of a lot of human rights movements at the moment is facing a significant challenge from the rise of right-wing populism. And right-wing populism often includes an element of what's called penal populism, the urge for harsh punishment. This is producing stronger resistance to abolition and even efforts to reverse abolition in countries where abolition has already taken place, like the Philippines, lifting of moratoriums. This is a dilemma that the Human Rights Project faces today. The second dilemma is the relationship between abolition of capital punishment and other reforms that might be taken in regard to criminal punishment. One example of this is the movement to end life imprisonment without parole, particularly in Europe, where the death penalty is almost completely abolished. The human rights movement has moved on and dealt with excessive life sentencing without the guarantee of a possibility of review of the appropriateness of release. And yet this is taking place at a time when in the world there is uneven progress toward abolition. And so that raises a problem for global human rights advocates with regard to what position to take with regard to life imprisonment. Whether life imprisonment can be successfully limited and opposed without creating an obstacle to the abolition of the death penalty, because so often part of the argument for abolition of the death penalty as a pragmatic argument within states that are hesitating about abolishing the death penalty is the argument that there are other forms of incapacitation that take the place of the death penalty and can serve human dignity or be more consistent with human dignity without inflicting death. And so that's another dilemma that the project faces. And a related dilemma is the question of what to do about moratoriums, and moratoriums being regarded as a form of de facto abolition. Is the adoption of a moratorium on the death penalty ultimately to be seen legally as an irreversible step? Is a moratorium an intermediate step which paves the way toward a recognition that the death penalty is unnecessary and inhumane and should be abolished, but that leaves the choice of abolition still to the state. Or after a moratorium has been in place for a long period of years, is it then irreversible? One question would be, is it irreversible as to the people who have been sitting on death row all this time, protected for the moment by the moratorium? And there, I think there is a strong argument that for the people who have been in that position for years, it is cruel to leave them in uncertainty as to what their fate will be for all those years. And it is cruel after years of moratorium to then turn to those people and say, it's now finally your time to be executed. But there's also the question of whether the moratorium is irreversible prospectively, in the sense that the state can never then return to the carrying out, the sentencing and carrying out of the death penalty in the future. And if that conclusion is drawn, then what is the incentive that that creates with regard to the states that have not yet adopted a moratorium, who we are hoping can be induced to engage in a moratorium, which will then persuade them and their population that they don't need the death penalty. That's another one of the dilemmas. The third dilemma relates to religious traditions that support the death penalty. The most prominent example of that, discussed several times in the book, is the example of Islam. That is not the sole example of a religious tradition which supports the death penalty, but in the international politics, it's the most important example, and it's the only one that, in my experience, I've seen as giving the reason for governments to come forward and say that our right to exercise our religion takes precedence over international commitments that might stand in the way of the death penalty, that might stand in the way of the death penalty. Now, it's not just governments that come forward and make these arguments. It is ordinarily also the case that there are wide swaths of public opinion among the citizens of those governments that there is religious support for the death penalty for particular crimes. And one thing that one can hope for is a reinterpretation of the religious doctrines, a reinterpretation of what it is that the religion truly requires. But that is a debate as to which outsiders have rather questionable standing to engage. When I was on the Human Rights Committee, we met with the International Commission Against the Death Penalty, and in that conversation, I asked them for their strategic advice. The International Commission Against the Death Penalty, as you may not know, is a transnational group of dignitaries that makes some public advocacy on the death penalty, but that also engages in a lot of quiet diplomacy for abolition. And so I asked them what their strategic advice was to the Human Rights Committee as to how it should engage in persuasion with Islamic governments. And the reply that came back was that change on this subject must come within, that outsiders can only do so much, but that the change must come from within. So we can and did make legal arguments where commitments already existed, but the goal of global abolition is going to depend on internal change, I think, in that area. So those are the reflections that I wanted to add to this truly extraordinary book. Thank you.
So thank you. So I pick up next. So I want to thank you for inviting me. I want to congratulate Jordan and Carol for an extraordinary book, not only because of the importance of the topic, but as well because as a study in thinking rigorously about law and social change more broadly, it is incredibly illuminating in its thematic approach. Very impressive scholars and activists from 4 continents involved in it. Now, as several authors note, the trend globally has been toward abolition in law, be it total or in reduction of number of offenses, and increasingly in retention of states in practice in the manner described, where, as Jerry mentioned, it's still on the books, but not carried out. And yet, as Carol and Jordan indicate, it's far too early to take a victory lap, as was mentioned, Turkey or Philippines, reverting, other countries adding terrorism as capital offense. And as Jordan and Carol indicated in the book, difficulties remain in explaining causality. So I have a lot of observations about the book, but in the interest of time, I'm limiting myself to 2 coming from areas that I study, China and disability. So the first concerns the fact that the US and China are far and away the 2 most prominent nations with respect to death penalty, as Carol and Jordan note, and as Michelle Miao, who contributed an excellent chapter, also observes. It would be hard in many ways to find 2 more different nations on the face of the earth, notwithstanding Donald Trump last year praising China for having the death penalty. And if we take these differences between the US and China seriously, I think that poses some real challenges for thinking about causation and a global strategy to move toward abolition. After all, the US, even with our current administration's approach about immigration, remains a nation of immigrants, whereas in China, 93% of Chinese are Han Chinese, and even the 7% who aren't have long been resident in China. Capital punishment here, as Carol and Jordan point out, and other authors note, is interwoven with our tragic history about race, and there's no exact counterpart to that in China. Then there is our attachment via the Second Amendment to guns in the hands of citizens, which surely is not the case in China. And for all our many problems in this country, the US does, at least as of yesterday, remain a vibrant democracy with a strong constitution and a reasonably well-functioning legal order, which are not watchwords for how one would describe China today. We prize transparency and open debate and have a pretty robust civil society here, varied religious groups that are highly independent. Again, not something one would characterize as typical of China. And although China has made enormous strides in lifting 800 million people out of poverty, the economic levels in the 2 countries obviously are quite different. The fact that both are retentionist, while so different, suggests to me some points that might be useful in thinking about strategy to move toward further abolition. So the first would be to eschew grand generalizations about culture or correlations between particular circumstances and what that means for how a nation lines up along the retentionist, abolitionist spectrum. I mean, again, 2 very different countries. Another is to be very wary of arguments about trends and what our former colleague here at Harvard, Ryan Goodman, now of NYU, termed acculturation. That is, that more than coercion or persuasion, nations acculturate. They wish to copy other countries in undertaking new practices. That might work for Estonia, as was noted in passing in the book, but I think it's a totally different thing when you're dealing with large and powerful countries. And we should not assume that all acculturation necessarily runs in a positive direction toward abolition. Indeed, as Jerry said, we're seeing now some acculturation in the other sense of xenophobia, hatred, spreading around the world. So acculturation, to the extent one believes in it, can run both ways. Third, I think we need to go to a more refined level. So obviously in the US, looking at states, smaller geographic units, although even here, acculturation is pretty hard to prove out. After all, look at Texas and Massachusetts, right? We haven't acculturated each other, and we're not likely to soon. And so with that, hence, what works in one setting may or may not work in another and could even arguably be counterproductive. It may, for instance, be hard to promote norm cascading via civil society in a country that has little in the way of independent civil society, or impact litigation in a setting in which the courts function really differently. Think of elected judges in the US responsive to, calls for tougher penalties, or think of China with the role of the party in the judiciary, as opposed, on the other hand, to German civil service-like judges with a high degree of independence. I think in the end there's something to be said for the hard work of plain old persuasion, laborious though that may be, and as much as it will require constant adaptation to new and different settings, something that happily this book does with enormous rigor and intelligence and honesty. A last word about China with respect to persuasion. There's a lot that we don't know, starting with the number of executions in China. The mere fact that this is kept secret should tell us something about the Chinese government's appreciation that there's something wrong with its extensive use of capital punishment. I think that the threat, if not the use of capital punishment, is deeply ingrained in this type of Leninist approach to governance. But since I don't want to end this part on a note of despair, let me suggest that perhaps one step that could be taken is to develop and present to policymaking elites in China additional data about other jurisdictions. By that I mean showing that societies that have abolished the death penalty are actually far less violent than those, such as the US, which retain it. I understand the problems there with causation and the other factors such as access to guns skew some of the conclusions, but still I think these examples could be persuasive given with proper caveats. I'm reminded here of a dear friend of mine, Professor Liu Renwen of the Chinese Academy of Social Science, who, as Carol knows, was here several years ago, who proposed an experiment to higher-ups in the Chinese leadership saying, well, since some American states have abolished death penalties and others haven't, why don't we in China do an experiment and abolish in some province, at least temporarily, and not in others? It didn't take hold, but it was the kind of out-of-the-box creative thinking that I believe important. My second point is a more delicate one even, and comes out of my interest in disability rights and disability law. I was struck by the thoughtfulness of the discussion by Professor Sandra Babcock of Cornell and others of the treatment of intellectual and mental health disabilities with respect to capital punishment. On the one hand, it seems to me especially barbaric to execute individuals who might not fully appreciate the implications of their actions. Indeed, I have to say, I have always thought that Bill Clinton's true character was revealed when, to show how tough he was, he broke off from his 1992 presidential campaign to return to Arkansas to oversee personally the execution of Ricky Way Rector, a person with severe cognitive limitations, an act that I believe ultimately showed not how strong Clinton was, but how weak he was as a person. So mental health, intellectual disability, capital punishment. But here, there are a lot of complications also. The UN Convention on the Rights of Persons with Disabilities purposefully does not contain a definition of what we mean by disability of any type, because there is such variety around the world in how countries approach this, and maybe especially so with respect to mental health or intellectual disability. What's understood in one country as a disability is not necessarily in others. Secondly, there's an argument advanced by some disability rights activists, advocates, that those of us who do not have a disability may be too quick to ignore the agency of persons who do, and hence we should be careful about advocating for any limitation on capacity, denial of somebody having capacity, even if that results in having responsibility and punishment. And finally, there is a really tough question that comes up also with respect to international humanitarian law, whether by taking the most horrific and appalling examples off the table, we might inadvertently be saying that less extreme practices, such as executing people who do not have an intellectual disability, is somehow legitimate. Please understand, I'm strongly in favor of abolition with respect to persons with intellectual disabilities, mental health disabilities, and anybody else in the world. But in the spirit of this wonderful book and the candor, I can't underscore enough its candor in exposing things that aren't yet worked out. In the spirit of that, I did want to raise this hard question as we think about how best to work toward abolition. Thank you very much.
Again, thanks to the Steikers for this marvelous piece of work, incredible contribution, and most especially a piece of work that will, I think, guide practitioners, jurists, and death penalty advocates, both lawyers and others who are working towards our ultimate goal of abolition. So thank you very much, and thank you for inviting me. I come to this work through my engagement with the death penalty in the Caribbean. As you know, I got involved in the issues around the death penalty in the Caribbean around 10 years ago when I was thinking about exploring the use of the penalty in states that where there are populations of color, but the issues of race that dominate the use of the practice here don't exist. And so I wanted to look at the Caribbean and consider why the death penalty remains such a potent force in Caribbean criminal justice, notwithstanding that the racial issues which seem to drive the use of the penalty here in the United States did not exist. So when I got there, of course, I was very surprised to find out that the penalty in part was sustained on the basis of this strange thing called the Savings Clause, which brings into modern Caribbean constitutional jurisprudence all of the law and penalties that existed prior to the independence of those states in the 1960s. And so I'd never heard of the Savings Clause. I got interested in it. I started writing about it. And then I also went down to the Caribbean, to many of the states, and began to talk about my work with audiences with whom I had engaged previously around general social justice issues, women's rights, labor rights, and I brought to them these death penalty questions and really got very hostile reactions. I mean, I sort of got, basically by my Caribbean friends, I kind of got booted out of the field. You don't know our problems. You don't know what we face down here. Fine, we'll talk to you about women's rights, but we're not going to talk to you about the death penalty. And I got that both from my activist friends as well as from my academic friends in the region, and so I left the field. So I just want to say a little bit about where things are with the Caribbean in relationship to the themes in this book. First of all, in terms of norm cascades, it's true that but for the full development and full exposition of international human rights norms, the domestic evolution of these issues certainly would never, we wouldn't have, it wouldn't be there. And that seems to be a theme that runs through this book, and certainly it's true in the Caribbean. In addition, regional formations, the importance of the influence of other developments across the region reflected in many of the chapters of this book also characterize the situation in the Caribbean. And finally, I want to say a few words about the Steiker's suggestion that democratic practice, democratic structures, and liberalism are correlated in some way with abolition, because that I don't find that to be true in the Caribbean. It's a small area of the country, of course, of the world, of course, but it is a critically important one when it comes to abolition. All of the Eastern English-speaking Caribbean states retain the death penalty for murder, and a majority of those states also retain the death penalty for treason. They have a very active death penalty population, and although the last execution in those states was in 2008, they continue to actively impose the penalty. When the UN every year has considered a resolution moving towards abolition, virtually all of these states have voted against it, and they constitute a 25% block of states worldwide. So it's a significant region in the overall struggle towards abolition. So what's driving this? In part, it's a very high crime rate. It has one of the highest crime rates in the world, according to the Inter-American Development Bank. And so that's certainly one reason. And so, what have been developments towards abolition given these circumstances? Well, prior to 1965, prior to the independence movements in the 1960s, these states were essentially governed by UK law. And post the 1960s, the independence movements, the Privy Council in the UK was the appellate court for the region. And while the UK obviously abolished the death penalty itself because of these savings clauses, which carried forward the old penalties into the new Caribbean constitutions, the Privy Council did not feel itself in a position to abolish the mandatory penalty. What it did do was to tinker around the edges of the penalty, and it addressed something called the death penalty phenomenon, which was the result of ongoing appeals through both the national and international systems that left people on death row for long periods of time. And in the case at hand, the Privy Council found that 14 years on death row was unconstitutional. Even if the penalty itself was constitutional, the delay was unconstitutional. So it didn't, as I say, it did not touch the question of the mandatory penalty, but worked around the edges of the mandatory penalty. And at a certain point, this is kind of a strange phenomenon, but at a certain point, in response to the Privy Council's decision-making on the death penalty, partially in response to the Privy Council's decision-making on the death penalty, the Caribbean states created their own court, their own regional court, called the Caribbean Court of Appeal. The Caribbean Court of Appeal, created in 2005, for a series of years, retained the jurisprudence of the Privy Council, but eventually, a year and a half ago, the Caribbean Court of Appeals rejected and deemed unconstitutional the mandatory penalty, and thereby rejecting the earlier jurisprudence of the Privy Council. So what does that tell us? First of all, it speaks to the critical importance, first, not only of these international norms, international developments on the international front, but the ability of states to fully incorporate them and create indigenous practices that, while influenced by international standards and norms, can be deemed to be indigenous. And I think that's what it took, that it took a period of time for the Caribbean Court of Appeal to feel that it had developed a sufficient depth in its own jurisprudence, a sufficient confidence in its own jurisprudence to reject that of the Privy Council, and to declare the mandatory sentence unconstitutional. The court was very careful to say that it's not striking the penalty as a whole, but certainly it's moving in that direction. I actually think that this is not something that's reversible. Unlike the Philippines, I think the Caribbean states will continue to go in that direction. It also speaks to the importance of the court. In this case, the governments themselves would not have moved in this direction without the leadership of a court that had to feel the confidence, gain the self-confidence to address this question. And as far as the future is concerned, the Steikers mentioned the importance of the United States as a player in this whole field. And certainly, although the Caribbean states do continue to relate to the Commonwealth, the geographic proximity of the U.S. And its continuing insistence on the death penalty affects the ability of the Caribbean itself to declare what its own human rights practices are going to be. And finally, as I said at the outset, I do have a bone to pick on the Steiker's conclusion that democratic practice, democratic structures, liberal practice and democratic structures seem to correlate with abolition. So the Freedom House, which, as you note, is a tracker of freedom, as it were, across the world, ranks the U.S. somewhere in the 80s, and most of the Caribbean states somewhere, the states I'm talking about, somewhere in the 90s. They have, very deep and thoroughgoing liberal commitments and democratic institutions. And yet you do find, nevertheless, that this very entrenched, deep, and ongoing commitment on the part of the populace to the death penalty in a situation where they don't have to look at the racial consequences or the racial sequelae of the practice seem to override these democratic impulses and practices. Thank you.
So, thank you so much for your very illuminating comments. Really very interesting. I'm just going to do a brief response to some of them. I agree that there is the fragility of abolition, global abolition, because it is an elite project. And it's not just that it's an elite project, it's one of the very few criminal justice areas where most of the change has been in part because of the exportation of the norms and the advocacy. And I think that the most significant thing over the past 40 years is the change of the view of the death penalty as an issue of ordinary criminal justice to an issue of basic and fundamental human rights. And the jurisdictions that have absorbed that view have likely turned to abolition, and the jurisdictions that haven't absorbed that view are largely, although not all, retentionist. So that complicates any strategic question about how to achieve global abolition, because many of the remaining countries are the ones who are least likely to view international human rights norms as controlling on this issue. And it was interesting when Bill suggested, from a strategic perspective, that maybe we approach China with sort of the federalism idea of the United States, sort of experiment with different policies. That's still sort of encouraging the viewing the issue as an issue of ordinary criminal justice and just see what's the best way to achieve ordinary criminal justice. And it may be, and I think it might well be in the United States, that when abolition occurs in the United States, it's not going to be like the rest of Western Europe, where it's done on a view of the death penalty as a human rights issue, but it may well be that we abolish the death penalty in the United States for much more prosaic, practical, and instrumental grounds that it's just bad criminal justice policy. It's not achieving much. I think I may disagree with Margaret about the connection between sort of democracy and liberal institutions, because I really think that the Caribbean story is a story, as you point out, of path dependence and the savings clauses, because it's hard for me to see that there would be as widespread retention had there not been the savings clauses. There would have been the opportunity for the new constitutions to be read in light of the very strong terms that could have been invoked to abolish the death penalty. So I think that I view, obviously, the death penalty remains popular for many of the same criminal justice reasons that it remained popular in Europe before abolition and that it remains popular in the United States. But I do think that a slightly different world without the savings clauses would have precipitated abolition and the connection between constitutionalism and rights-protecting provisions in the Constitution. Very interesting issues about the connection between the death penalty and life without possibility of parole, and the death penalty and protecting particularly vulnerable groups such as persons with severe mental illness or people with intellectual disabilities. I think, Carol and I have wrestled with those questions a lot as on the strategic basis. In Texas, it was an enormous issue whether or not to support life without possibility of parole, which did very strongly lead to the decline of the death penalty in Texas. The death penalty in Texas, the number of death sentences has fallen off a cliff, just as it has throughout the United States, where we have, a fraction, about 10% of the number of death sentences that we had produced in the 1990s. And I think life without possibility of parole is one of those reasons. But from an international human rights frame, the idea that we've substituted, one human rights violation for a different human rights violation doesn't seem like a lot of progress. And it's been, and in fact, many, many more people are serving life without possibility of parole than would otherwise have, who would never have gotten the death penalty. So we've actually radically expanded a practice that is very problematic, in part as a way of attacking this very marginal institution in the United States, the death penalty. I think Carol and I both strongly believe that it's important to continue to narrow and reduce the scope of the death penalty's footprint and to exempt persons who are, from a retributive perspective, much less deserving. We've always worried about the sort of stabilizing effect of making the death, sort of the new and improved death penalty. But I actually think that at least the experience in the United States suggests that it actually hasn't, I think, worked out that way. I think that the more folks who are sort of excluded from the death penalty, I think the stronger the arguments that we really don't need the death penalty. And if we actually were to eliminate the death penalty for, persons who have, for, expanding the definition of juveniles to the sort of, in light of brain science, to 25, you would really cut out the heart of the American death penalty if you exempted persons under the age of, say, 25 from the death penalty, analogizing to the exemption for juveniles. But these are very rich comments, and I very much appreciate them.
Great. Well, I have to, share my gratitude for this amazing group of commentators, and you've given us so much food for thought. I want to hear, you don't often get a group like this that you can ask questions to. So I'm just going to say something very briefly, because we welcome your questions and comments and take advantage of this group of unbelievably illustrious, interesting experts. I would just say the thing that, to me, that links all three comments is the way in which advocacy toward ending the death penalty globally has to come internally. So, Bill is talking about China and what's going to appeal to China. Let's not talk about acculturation of China. China's a big, player. It's not going to be acculturated, by tiny little, by Estonia, for example, whereas Estonia might be acculturated by the EU. Jerry says, you can't tell Islamic countries what Islam means. If they say Islam means the death penalty, it's got to come internally. Margaret says, the Caribbean, they're democracies, but they have a different view of democracy. I go down there and talk to my peers there, and they have a very different view of the death penalty. So you've got to, it's got to come from internally from each place. But as Margaret says, the US abolishing the death penalty. Now, acculturation may work on the Caribbean. They are Estonia, more or less, relative to the US. Estonia to the EU, Caribbean to the US. There is a possibility of a norm cascade there in a way that's not true about China. So this is where I really take in and agree with Bill's sense that there isn't some, global, generalizable checklist, that it's really got to be internal, and take the elite point too, that the elites in all of these contexts have to be convinced. And sometimes those are judges, sometimes those are legislatures, sometimes those are presidents or ministers of justice, sometimes they're religious leaders, and it's going to be a different story in different places, and fascinating, difficult work on the global scale. Anyway, I'm just so grateful and happy, and now I turn the microphone over to this group. So there's literally microphone here. We'd love to hear your comments and questions.
Thank you very much. The discussion on acculturation made me think about the relevance of the comparative and the foreign to this country's own jurisprudence on the death penalty. Would it be fair to predict that the foreign will become less relevant given the recent compositional changes to the court, especially with the retirement of Justice Kennedy?
I think that's quite likely. In recent death penalty decisions, when the court has sort of operationalized the Eighth Amendment, there was a sort of famous footnote in one of the cases that exempted the death penalty for persons with intellectual disability that said the court found confirmation in world practices and the views of other countries that the death penalty was excessive as applied to persons with intellectual disabilities. And then Justice Kennedy wrote a much broader opinion when the court exempted the death penalty for persons with juveniles, in which he relied very heavily on the fact that the United States was alone in the world in officially authorizing the death penalty for juveniles. So it seemed as though Justice Kennedy was dedicated to looking at practices and law outside of the United States as indicative of the meaning of what counts as cruel and unusual punishment. That's certainly not the methodology of the current court, I don't think, but it would take, in some sense, an overruling of the methodology that the court has embraced. So I do think that your instinct is right, that this court does not seem to be a court that would be inclined to look outside the United States. It's much more likely to look at from a textual and an originalist perspective, what the expectations were, at the time that the Constitution was drafted and the subsequent history.
I just quickly note on February 24th, Mary Ann Glendon's giving a talk, do we need foreign laws? So you might want to, people interested in Jem's question might want to come.
So, Professor Newman, you referred to life without parole internationally. Last time I looked, I think every American state but Alaska authorized it. What's the situation internationally? How frequent, how many countries use life without parole?
So I can't give you any statistics on that. What I want to say in terms of the human rights framework is, first of all, that life without parole for juveniles is prohibited by the Convention on the Rights of the Child, to which every country that is a member of the United Nations, except for one, is a party. And second of all, that the European Court of Human Rights has banned what was called in British terms the irreducible death penalty, which is the equivalent of what we call life imprisonment without parole. And then the question has become how much is that jurisprudence going to spread to other regions and to the global human rights system? And it was in that context that I confronted it, and that's where one faces the dilemma of trying simultaneously to pursue a reform agenda in understanding what are cruel punishments which should be prohibited, and what about the cruel punishment of death?
So if there's a distinction between punishments that are sometimes permissible and then punishments that are absolutely impermissible, I'm just wondering how you all think about that distinction, how you justify it. So if life without parole and capital punishment are clearly on the other side of the line, how do we distinguish those punishments from, say, a 40-year sentence with the possibility of parole? And so the broader question is just, is there anything special, or what makes those sorts of forms of treatment unique in a way that they should be absolutely prohibited?
Well, that's a really interesting question, and I think there's two pieces to your question. One is, are you asking as a matter of morality, or are you asking as a matter of law? So those two things, as we know, are not always the same. And so moral theorists have a variety of approaches to punishment, and it depends on what your theory is. Like, if you're a retributivist, you might think, as Kant did, that, the death penalty is not only permissible, it is indeed required to respond to certain wrongdoing. But if you're a deterrence theorist, it would be permissible if and only if that it achieved a degree of deterrence that you needed, or, death is the only perfect incapacitator, if there was really a threat, so the moral question depends on your theory of punishment. The legal question, at least, I think Jerry can talk more about the human rights bases for banning some of these practices, but in the United States, it's cruel and unusual punishment, which sounds moral, but it is a legal standard. And in the US, the question has to do, ironically, because it's a constitutional question, you wouldn't think it has to do with legislation, but that is in fact largely what the court looks at. It looks at, is this an outlying practice that there is an emerging consensus against? And to be fair, that's the first part of the court's analysis. And the second part is, does it promote any permissible theory of punishment, which is the moral philosopher's question. What I find funny, and I always laugh at the court about it, in every one of the many, many cases the court has decided, they always think that those two answers point in the same direction. And there's no reason to think that that would be the case, that the consensus of legislative practice and the moral philosophers' justifications of punishment would point in the same direction, but they stand on their heads to make that happen, because, which one prevails if they don't? So that's where we stand on the moral and the legal questions, I think. I think we have maybe time for one more quick question before we break, if there's another one.
Hi, thank you. I'm wondering if you can maybe project into the future in terms of how the death penalty is accepted here in this country, and see whether abolition of it would follow more along criminal justice lines or along the human rights position, and then the distinction between doing that on a state level versus a federal level.
I think that the United States is destined to abolish, and I think that, given our federalism, the only way that would be achieved would be through a decision by the U.S. Supreme Court. And I think the various sort of seeds of what an opinion would look like have already been, given to us, and I think the most likely ground that the Supreme Court will invoke will not be sort of a human rights, human dignity frame, but an argument that the death penalty, when it is so infrequently and sporadically applied, can't be said to achieve any permissible penological purpose, that we don't execute enough people and consistently enough, and consistently identifying the worst offenders on a regular basis, that it actually can be said to serve retributive or deterrence purposes. And I think the case for that just grows every day as more jurisdictions abandon the death penalty, and the death penalty gets marginalized to a very few jurisdictions, and death sentences become exceedingly rare. I mean, we've had fewer than 50 death sentences a year over the past several years, where we were over in the 300s in the 1990s. When it becomes so extraordinarily rare, it's hard to say that the death penalty serves something that we need more than very long incarceration. And I think there's very little ground in our constitutional history and doctrine for a human rights approach where we say that the death penalty is somehow inconsistent with human dignity, creates an inappropriate relationship with the state, it amounts to torture, all of the arguments that have had a lot of purchase in Europe and in many other areas where the death penalty is abolished. Those arguments just don't have much of a pedigree in our Constitution and constitutional history.
Well, thank you all for coming, and please join me in thanking this incredible panel.